Drake lost a legal round, but losing a lawsuit may not be what worries a superstar most. Drake lost a significant legal round in the case connected to Not Like Us, but for an artist of his scale, losing a single filing in court is not necessarily the most damaging outcome imaginable. What tends to be far more consequential for a figure who has spent years building one of the most carefully maintained public personas in contemporary music is the moment a rap beef stops being about music at all and begins transforming into a full-scale public image crisis, one that pulls in legal institutions, major media outlets, and the unrelenting pressure of public scrutiny all at once. Before going further, it is worth being clear about what this piece is and what it is not. This is not a gossip breakdown, and it is not an attempt to pass moral judgment on any individual involved. The approach here follows the documented public record, the court filings, the judicial decision, the appeal, and the measurable public response. The goal is to understand why this story has refused to cool down and why it continues to generate conversation well beyond the world of music commentary. Where possible, the analysis draws on major wire services, including Reuters and the Associated Press, as well as coverage from Billboard Canada, to keep the discussion grounded in verifiable fact rather than speculation. To understand why every development in this story carries the weight that it does, it helps to start with a simple but important fact. Drake has not faded. He remains one of the most streamed artists in the world and continues to hold a commanding position in global music metrics. For an artist with that level of active cultural presence, no controversy sits quietly in a corner. It expands. It gets picked up, reframed, argued over, and amplified across platforms in ways that a smaller profile would never invite. This is not simply a story about entertainment industry gossip. It is a story about a narrative war being fought at a very large scale, and the outcome of that war will be shaped not only by what happens in courtrooms, but by what happens in comment sections on streaming platforms and in the ongoing court of public opinion. What made this particular dispute different from a conventional rap feud was the decision to escalate it beyond the domain of music. Drake chose to pursue a legal path rather than limiting his response to artistic output alone. In doing so, the central question shifted dramatically. It was no longer primarily about who delivered the more effective diss or whose bars landed with greater cultural impact. It became a question about responsibility, about the consequences of amplified narrative, and about who bears accountability when content that one party considers harmful is distributed and promoted at scale. Notably, the legal action in this branch of the dispute was directed not at Kendrick Lamar directly, but at Universal Music Group, the major label that served as the distribution and promotional infrastructure behind Not Like Us. That targeting of a corporate entity rather than an individual artist gave the case a structural dimension that added genuine legal and industry interest to what might otherwise have been read as a personal conflict. The ruling that followed was delivered by Judge Jeanette Vargas, and it is worth spending real time on what that ruling actually said, because the shorthand version that Drake lost obscures the reasoning in ways that matter. Judge Vargas dismissed the lawsuit, but the dismissal did not rest on a finding that the content of the song was insignificant or that the allegations it contained were trivial. The court acknowledged that the accusations were serious. The legal reasoning turned on something more specific, the context in which those words were delivered and received. In the framework of a heated, very public rap battle, the court found that a reasonable listener would not interpret the lyrics as verifiable statements of fact. The language was classified as non-actionable opinion, which in the legal tradition of defamation law means it falls outside the category of claims that can be pursued through defamation action. For a statement to be actionable as defamation, it must be understood by a reasonable audience as a factual assertion rather than an expression of opinion, hostility, or artistic aggression. The court concluded that the context of a rap battle, with its well-established cultural tradition of exaggeration, confrontation, and rhetorical combat, placed the content outside that threshold. This is not a minor legal footnote. It reflects a genuine and unresolved tension that courts in Canada and elsewhere have been navigating for years. How do existing legal frameworks designed for an earlier media environment apply to an art form that has always used provocation, hyperbole, and personal attack as core elements of its language? That question does not have a clean answer, and this ruling does not resolve it permanently. It adds to a body of precedent that courts and legal scholars will continue to interpret and debate, particularly as the reach of individual songs grows larger and the velocity at which content travels across platforms continues to accelerate. What the ruling also did not do was end the matter. Drake filed an appeal following the dismissal, a development confirmed by major newswire services. That decision carries its own significance. It means the formal legal process remains open. It means journalists, commentators, and members of the public who have been following this story have ongoing reason to keep watching. The narrative has not been archived or resolved. It has simply entered a new phase, and with that new phase comes a fresh cycle of media attention, public debate, and image management that shows no sign of slowing. There is a dimension to this story that goes beyond the courtroom and beyond the music, and it is one that deserves careful handling. When a public dispute of this magnitude extends over time and grows to encompass legal proceedings, it stops being something an artist can contain within the professional sphere. It begins to touch the more personal terrain of public life, how a figure is perceived not just as a performer, but as a human being, how their choices are interpreted by people who have never met them, and how the weight of sustained public scrutiny shapes the experience of simply living in the open. Drake has not spoken extensively about the personal toll of this period in ways that are part of the documented record, and this piece will not speculate about what is not confirmed. But it is fair to observe, in general terms, that when a controversy of this scale moves from the stage to the courtroom to the front pages of major outlets, the artist at the center of it is no longer being heard as a musician alone. They are being read as a symbol, a brand, and a person simultaneously, and those three things rarely coexist comfortably under that kind of pressure. The deeper analytical question, and the one that gives this story its lasting interest, is about what Drake is actually trying to accomplish. Two interpretations have emerged from commentary across the spectrum of informed observers, and both are credible enough to take seriously. The first is that Drake is engaged in a deliberate effort to reclaim control over the narrative surrounding his name. Losing in the arena of musical competition is one kind of outcome. Allowing that outcome to stand as the defining story without challenge or response on any other front is quite another. By pursuing legal remedies and continuing to appeal, Drake moves the conversation away from the question of who won the rap battle and toward a different set of questions about the ethics of promotion, about the responsibilities of major labels, about the point at which artistic expression crosses into demonstrable harm. Whether or not those arguments ultimately succeed in court, the act of making them keeps the frame open and active in public discourse, which is itself a form of narrative control. The second interpretation is less favorable, and it represents a sentiment that a meaningful segment of the public has expressed with some consistency. Under this reading, the legal strategy looks less like a principled stand and more like an unwillingness to accept a result that was already settled on the terrain where it began. Not Like Us achieved a cultural footprint that extended well beyond the beef that produced it. It was performed at high-profile public events, discussed in outlets that rarely engage with hip-hop commentary, and streamed at numbers that reflected genuine, widespread interest. For people who hold this view, the ongoing legal campaign resembles the continuation of a conflict by other means, a refusal to move on that ends up keeping the very story alive that might otherwise have faded. This interpretation tends to sharpen the division between Drake's supporters and his critics, and that polarization, paradoxically, contributes to the story's continued visibility and virality. What this situation ultimately illuminates is a question that is going to matter more, not less, as digital media continues to evolve. In an era when a single song can reach hundreds of millions of listeners within days of release, when lyrics are extracted and shared as standalone text entirely divorced from the artistic context that produced them, And when the distinction between a performance and a public statement becomes genuinely difficult to locate, the frameworks that exist to manage these disputes are being asked to do something they were never quite designed to handle. Canadian courts, like courts in other jurisdictions with robust free expression traditions, have historically been careful about the boundary between protecting reputations and chilling creative speech. That balance is under pressure in the current environment in ways that earlier legal thinking could not fully anticipate. None of this resolves neatly into a verdict. Drake lost a round in court. He has appealed. The song that prompted the lawsuit continues to exist and to be heard. The artist who made it has not been a defendant in this particular proceeding. The label that promoted it is the one facing ongoing legal scrutiny. Public opinion remains divided along lines that largely reflect prior loyalties rather than dispassionate assessment. All of these things are true at the same time, and none of them cancels the others out. The question worth sitting with is not simply whether Drake was right or wrong in pursuing this path. It is a bigger question about what control actually means for a public figure in this moment. In an age of diss tracks, viral clips, and media cycles that move faster than any legal process, can an artist truly manage the image that the public constructs around them once a story has escaped the boundaries of the music itself? And if that control is illusory, what does it mean for the way we think about reputation, responsibility, and the long reach of creative expression? According to you, is Drake defending a legitimate claim against genuine reputational harm, or has he become caught in an image war that costs more the longer it continues? Leave your thoughts in the comments below. And if you want the next video to go deeper into why modern rap beefs increasingly move from music into legal and media battles, that is exactly where this channel is heading next. Liking this video and subscribing keeps you in the conversation as the story develops.